Maggie, you have to understand, people like you do not usually get a second chance when developers make an offer this generous. Richard Cole said it with the patient smile people sometimes use when they believe they are explaining something complicated to someone who cannot possibly understand it. I was standing beside my old wooden fence with a pair of gardening gloves tucked into my back pocket, looking at a man who had lived next door for 11 months and apparently decided that was long enough to understand my entire life. People like me? I asked. Richard hesitated. I did not mean it that way. Then what way did you mean it? His wife, Vanessa, shifted uncomfortably beside him. Richard glanced toward my house, a modest brick ranch built in the early 1970s, then toward my 12-year-old sedan parked beneath the maple tree. His answer was already written across his face. I was 66 years old, widowed, quiet, and apparently insufficiently impressed by money. I only mean that this neighborhood is changing, he said. Property values are climbing. Development is coming whether any of us like it or not. Behind our houses stretched 18 acres of oak, maple, and hickory woodland, interrupted by an old meadow that turned golden every October. Most neighbors simply called it the Sullivan Woods because Edward and I had lived beside it longer than almost anyone remembered. Richard called it opportunity. Since moving into the renovated two-story house next door, he had talked constantly about what the land could become. 12 executive homes. Maybe 14. A private entrance. Landscaped common areas. He had numbers for everything. Edward would have smiled at that. My husband loved numbers too, but he believed numbers were useful only after you understood what they represented. Edward had been gone for 2 years. Some mornings, I still reached toward his side of the bed before remembering. Other days, grief felt less like pain and more like an empty chair that had become part of the room. We had been married 42 years. For more than 30 of those years, Edward worked as a licensed land surveyor and civil engineer. What very few people knew was that I worked beside him for most of that time. I managed contracts, property records, correspondence, county filings, and enough survey documents to recognize a boundary description faster than many young professionals. After Edward died, I stopped talking about the business. I did not need strangers to know what I had done before becoming the woman they saw watering tomatoes at 7 in the morning. Richard certainly never asked. The partnership is prepared to make cooperation worthwhile, he continued. I appreciate that, I said. But I am not agreeing to anything today. His smile tightened. Nobody is asking you to sign today. Good. We are only trying to help you understand the opportunity. Vanessa finally spoke. Richard, maybe Maggie wants time. Of course. He turned back to me. But these offers do not remain open forever. Neither do good tomatoes, I said, pulling my gloves from my pocket. And I have 6 on the counter waiting to become sauce. Vanessa almost smiled. Richard did not. They returned to their house, and I went inside. On my kitchen table sat an old photograph of Edward wearing a faded green field jacket, standing beside a survey tripod 25 years earlier. I picked it up and studied his familiar face. You would have enjoyed that conversation, I whispered. For several weeks, Richard's development plans had been moving from neighborhood rumor toward something more serious. 'Cause I did not recognize occasionally stopped near the wooded acreage. 2 men in reflective vests had walked along the county road carrying equipment. Richard had mentioned investors, preliminary engineering, and access studies. I had listened without correcting him because nothing he said required my response yet. That changed 3 mornings later. I was carrying a bag of yard waste toward the curb when something bright caught my attention near the back corner of my property. A wooden stake stood approximately 3 feet inside the brush, topped with fluorescent orange ribbon. I set the bag down and walked toward it. Another stake appeared roughly 70 feet farther north. Then another near the old stone drainage channel. I crouched beside the first one. There was no company name, only a handwritten notation and a number. I followed the imaginary line with my eyes toward the woods. Something about it felt wrong. I went inside, washed my hands, and opened the hall closet I had avoided for nearly 2 years. Behind winter coats and an old vacuum cleaner sat 3 grey document boxes labelled in Edward's handwriting. I carried the first box to the dining table and removed folders filled with plats, field notes, deeds, and survey maps. The smell of old paper brought back afternoons in our former office when Edward would return from the field covered in dust and ask whether I had found whatever deed reference he had forgotten to bring. I searched until I found a rolled survey dated 28 years earlier. Edward's initials were in the lower corner. I spread it carefully across the table and placed 2 coffee mugs on opposite edges to keep it flat. The 18 acres appeared exactly as I remembered them. So did the narrow strip running toward the county road. I compared Edward's measurements with the location of the new stakes outside. Then I checked again. My heart did not race. I did not feel frightened. I felt something I had not felt since closing our office after Edward became ill. Professional certainty. The new stakes were not following the boundary shown on Edward's survey. They were cutting across a section of land that had never belonged to the parcel Richard believed his partners were preparing to develop. I walked back outside and stood beside the orange ribbon moving gently in the Pennsylvania breeze. From Richard's patio, I could hear him speaking on his phone about preliminary access. He noticed me and lifted a hand. "Everything all right, Maggie?" he called. I looked at the stake, then toward the woods Edward had surveyed long before Richard knew this neighborhood existed. "I am not sure yet," I said. Richard smiled as though there could not possibly be anything there that he did not already understand. I smiled back, because I had just realized something he had not. Someone had put a property line in the wrong place. I went back inside without touching the orange stake. Edward had taught me that when a boundary looked wrong, the first mistake was assuming you already knew why. The second was moving anything before documenting exactly where you found it. I took my phone outside, photographed each stake from several angles, measured their approximate distance from the old fence line, and wrote the time and date in a notebook. It felt strange how naturally the old habits returned. For decades, I had watched Edward treat property records with almost ceremonial patience. "Land does not argue," he used to tell me. "People argue about what they think the land says." By noon, my dining table looked like our old office. I had Edward's 28-year-old survey beside county tax maps, copies of deeds, handwritten field notes, and a faded subdivision plat from before half the houses on our street existed. The more I compared them, the more certain I became that the new stakes were not simply a few feet off. The line appeared to be following an entirely different assumption about the narrow strip connecting the wooded acreage to the county road. That strip mattered because without practical road access, developing 18 acres became considerably more complicated. Around 2 o'clock, Richard knocked on my door. "I saw you looking at the markers," he said. I was. "Those are preliminary survey stakes. Nothing permanent." "Who placed them?" He gave me the name of a regional engineering company. I recognized it, although I had never worked with them. "Do you have a copy of the survey they are using?" I asked. Richard looked surprised. "The engineers handle that." "I understand." I asked whether you have a copy. "Not with me." "Then perhaps you should get one." His expression changed slightly. "Maggie, is there a problem?" "Possibly." "What kind?" "The stakes do not appear consistent with an older recorded survey." He smiled, and I could almost see him deciding how gently to correct me. Property technology has changed quite a bit over the years. Modern equipment is extremely accurate. Equipment can be accurate and still begin with the wrong record. That removed the smile. "You know something about surveying?" "A little." I did not. "Explain further." Richard looked toward the dining room behind me and noticed the documents covering the table. "Was Edward involved with this property?" "He surveyed much of this area." "That was decades ago." "Property boundaries do not become irrelevant because the surveyor gets older." Richard exhaled. "I am sure the engineering team has reviewed everything." "Then there should be no difficulty comparing their work with the recorded documents." He left politely, but not happily. The next morning, Vanessa stopped while I was collecting mail. "I hope Richard did not bother you yesterday," she said. "He did not. He gets focused when he is working on something. I have noticed." She glanced toward the woods. "He has been talking about this project for months. He thinks it could be one of the best investments he has ever joined. That explains his enthusiasm. He says those woods are mostly wasted land." I looked beyond her toward the trees. Edward and I had walked there hundreds of times. He knew where water collected after heavy rain, where the ground rose sharply beneath the leaves, and where an old stone wall marked a farm boundary that disappeared from ordinary maps generations ago. "Land is rarely wasted simply because nobody has built on it," I said. Vanessa seemed embarrassed. "I did not mean that I agree with him." "I know." That afternoon, I drove 12 miles to the county records office. I had not been there since before Edward became ill. The building had been renovated, but the familiar process of tracing deeds and parcel references came back quickly. I spent almost 3 hours following transfers backward through decades of records. One deed referenced another. That document pointed to an older parcel description. Eventually I found the legal description Edward had used when preparing his survey. Then I found something else. The narrow corridor near my property had once been part of a larger tract. During a transfer many years earlier, the corridor had been treated differently from the surrounding acreage. I copied everything and returned home before sunset. Richard was standing near his driveway talking with 2 men in business clothes. One held a rolled plan. Richard saw me carrying the county envelope. "Doing research?" he asked. "Yes." One of the men smiled politely. "Richard tells us your late husband surveyed around here." "He did. We would be interested in seeing anything relevant." "Once I know what is relevant, perhaps you will." Richard gave a short laugh. "Maggie is being very careful." "Careful is cheaper than correcting a recorded mistake later," I said. The man holding the plan stopped smiling. He introduced himself as Aaron Mitchell, a project engineer. "What mistake are you concerned about?" I pointed toward the nearest orange stake. "What monument did your crew use to establish that line?" Aaron looked toward the marker, then back at me. His expression sharpened immediately. Unlike Richard, he understood the question. "I would have to check the field notes." "Please do." "Do you have evidence that the line is incorrect?" "I have evidence that it deserves another look." Richard folded his arms. "This is becoming unnecessarily complicated." Aaron ignored him. "Could I see the older survey?" "After I speak with my attorney." That sentence surprised Richard more than anything else I had said. The following morning, I called Helen Brooks, the attorney who had handled Edward's estate. Helen was 62, direct, meticulous, and one of the few people who knew exactly how much planning Edward had done before his death. I explained the stakes, the proposed development, and what I had found in the county records. She was silent for several seconds. "Maggie, do not sign anything Richard brings you." "I was not planning to." "And do not give anyone copies of Edward's private files yet." Her tone made me sit straighter. "Why?" "Because I want to compare what you found with the estate records." "Helen, I thought this was only a boundary problem." "It might have started that way." I heard papers moving on her desk. "But if the access corridor is the one I think it is, this is not simply about where Richard's surveyors put their stakes." I looked through my kitchen window toward the 18 wooded acres glowing beneath the late afternoon sun. "Then what is it about?" Helen paused again. "Who actually has the right to control the road they need?" The next morning, I drove to Helen Brooks's office with Edward's old survey rolled carefully inside a cardboard tube and the county record stacked in a folder beside me. Helen had handled our legal work for almost 20 years, beginning with ordinary business contracts and eventually helping Edward organize everything after his health began to decline. She was one of the few people who never treated me as though I had merely been Edward's wife. When I entered her office, she already had several estate files waiting on the conference table. "Show me exactly what you found," she said. I spread Edward's survey beside the newer parcel map. Helen listened while I explained the orange stakes, the legal descriptions, and the old transfer involving the narrow strip leading toward the county road. She did not interrupt until I finished. Then she placed one finger on the access corridor. "This is what concerned me yesterday." "Because of the ownership?" "Because of the rights attached to it." She opened one of Edward's estate folders and removed a document I recognized immediately. Years earlier, Edward and his longtime business partner had acquired interests in several pieces of undeveloped property when this part of western Pennsylvania was still mostly fields and woods. Some parcels were sold. Others were reorganized. The 18 acres behind our neighborhood had remained untouched. "Richard seems to believe his development group can obtain access from the county road through this corridor," Helen said. "That is what his stakes suggest. They may be relying on an old assumption that the corridor transferred automatically with the surrounding tract. It did not." Helen looked at me. "That is what we need to confirm formally." I traced the boundary with my finger. I remembered Edward explaining the same irregular shape decades earlier. At the time, it had seemed like another technical detail among thousands. Now it could determine whether Richard's entire development plan worked as designed. "Do not tell him yet," Helen said. "Why not?" "Because we should know exactly what the current title records establish before you make any statement." I nodded. That was exactly what Edward would have done. 2 days later, Richard came to my house carrying a leather folder. Vanessa was not with him. "I think we can simplify all of this," he said after I invited him into the living room. He placed a document on my coffee table. "The development partnership would like an easement along the rear portion of your property." "For what purpose?" "Construction access initially, then permanent roadway access depending on final approval." "How wide?" "Approximately 40 feet. "And where does it connect?" He pointed to a preliminary diagram. The proposed route followed nearly the same line as the orange stakes. "You are assuming this corridor belongs to the development parcel," I said. "Our engineers believe the access is valid." That was not my question. Richard leaned back. "Maggie, even if there is some technical discrepancy, an easement from you could resolve it." "Perhaps. Or it could create a problem I have no reason to create." His patience began to thin. "You would be compensated." I assumed so. He named an amount large enough to sound impressive to someone unfamiliar with property development. I looked at the number and then at him. "No." Richard blinked. "You have not even considered it." "I considered what you are asking me to sign. That is a very generous payment for a narrow strip of land you are not using. You keep describing land by what you can build on it. That is generally how real estate value works." "Sometimes." He studied me. "What exactly do you want?" "At the moment, nothing. Everyone wants something." "Then perhaps that is another assumption worth reviewing." He gathered the papers more sharply than necessary. At the door, he stopped. "This project could raise property values throughout the neighborhood." "It could." "And you could benefit financially." "Possibly." "Then I honestly do not understand your resistance." "You do not need to understand it. You need to understand that I am not signing." The following afternoon, Aaron Mitchell, the project engineer, called me. Unlike Richard, he sounded careful. He had reviewed his cruise field notes and discovered that their preliminary line had been established using a digital parcel layer combined with a monument referenced in a more recent survey. "Your husband's survey appears to reference an older monument farther west," he said. "It does. We are trying to locate it. Look near the stone drainage channel, approximately 32 feet north of the old retaining wall." Silence followed. "How do you know that?" "Because I typed Edward's original field notes." Aaron paused. "You worked with him?" "For more than 30 years. His tone changed immediately. Richard did not mention that. Richard never asked. Aaron called again the next morning. His crew had found the monument exactly where Edward's notes indicated. Their preliminary line was wrong. Not dramatically wrong, but enough to change the relationship between the proposed roadway and the old corridor. By Friday, Helen had received an updated title report. She asked me to come back to her office. When I arrived, she closed the door and placed the report in front of me. "The developers do not control the corridor," she said. "Who does?" Helen turned several pages and pointed to a chain of recorded interests that eventually connected to Edward's estate planning documents. "This is where things become complicated. The access rights were preserved separately, and Edward made sure they remained connected to the larger land arrangement." I looked at her. "The 18 acres?" "Yes." I felt the room become very quiet. "Richard thinks he needs an easement across part of my residential property. He may need much more than that." "What exactly?" Helen folded her hands. "He needs permission from whoever legally controls the trust interest governing that land and its access." I already knew enough about Edward's estate to understand why her expression had changed. Still, I asked the question. "And who controls it?" Helen looked directly at me. "You do, Maggie." For several seconds, I simply looked at Helen. I was not surprised that Edward had protected the land carefully. That was exactly the kind of man he had been. What unsettled me was realizing that a decision he had prepared for years earlier had suddenly arrived at my front door wearing an expensive jacket and carrying an easement agreement. "I knew I was trustee," I said. "I did not realize the access rights were structured this way." "Most people would not," Helen replied. "Edward separated several interests deliberately. He wanted flexibility if development eventually reached the property." I looked down at the title report. "He always said this area would change. Apparently he planned for it." Helen explained that controlling the trust did not mean I could casually do whatever I wanted. There were legal duties, recorded restrictions, tax considerations, and other documents that had to be reviewed. But one fact was already clear. Richard's partnership could not treat the 18 acres as though the only remaining obstacle was convincing one elderly neighbor to allow a 40-foot roadway across her backyard. "What should I do?" I asked. "Nothing until we finish reviewing the trust. Richard will not like that." Helen smiled. "Richard is not my client." I drove home through rolling western Pennsylvania hills painted with October color. When I turned onto our street, two neighbors were standing near Richard's driveway talking to him. Their conversation stopped as my car passed. By the following weekend, I understood why. Richard had begun telling people that delays involving access could jeopardize the development. He never directly blamed me, at least not where I could hear him, but neighborhoods do not require official announcements for rumors to travel. On Sunday afternoon, my neighbor Carol Jenkins stopped while I was raking leaves. "Maggie, is it true they offered you money for an easement?" "They made an offer." "And you turned it down?" "I declined to sign." Carol lowered her voice. "Richard says the project could increase all our property values." "Perhaps it could. Then why would you stop it?" I rested both hands on the rake. "I have not stopped anything. I refused to sign a legal document before the ownership and access records were clarified." Carol looked disappointed, as though she had expected a simpler answer. "Richard said it was just 40 feet. 40 feet can matter quite a lot when someone intends to build a road through it." She nodded slowly and changed the subject. 2 days later, Richard returned with a new offer. This time Vanessa came with him. We sat at my kitchen table while Richard opened a folder and slid a typed proposal toward me. The amount was almost twice his original figure. "The partnership wants to resolve this professionally," he said. "So do I. This is significantly above what an easement of this size would normally command. Then you should feel comfortable withdrawing it until the title questions are resolved." Richard stared at me. Why would I withdraw an offer that benefits you? Because you still cannot tell me precisely what rights your partnership already owns. Vanessa looked at him. Richard tapped the proposal with one finger. Our attorneys are reviewing that. So is mine. His eyes narrowed slightly. Helen Brooks. Yes. You hired an attorney over this. Helen has represented my family for years. Richard leaned back. Maggie, I am trying to avoid turning a straightforward business arrangement into something adversarial. Then stop treating my request for accurate records as opposition. Vanessa looked down at the table. Richard remained silent for a moment. What would make you comfortable? He asked. A complete title review, the recorded documents governing the access corridor, the development plan, drainage studies, and clarification of who actually controls the 18 acres. His expression changed at the last sentence. The landowners control the acreage. Which landowners? The investment group is negotiating with the ownership interests now. That was not my question. Vanessa looked from him to me. Maggie, do you know who owns it? I know enough to wait. Richard closed the folder. You are making this more complicated than it needs to be. You have said that before. Because it is true. Sometimes something looks simple only because you are missing information. He stood, and Vanessa followed. At the door, she turned back. Thank you for the coffee. Richard said nothing. The following morning, Helen called. She had completed another stage of the estate review. I need you. In my office tomorrow, she said. There is a document Edward prepared that we need to discuss. My hand tightened around the phone. What document? A memorandum connected to the trust. I do not remember a memorandum. You were not supposed to receive it when the trust was established. Why? Because Edward instructed that it remain sealed unless a specific condition occurred. I sat down at the kitchen table. What condition? A formal dispute involving disposition or access to the property. For a moment, all I could hear was the refrigerator humming behind me. And this qualifies. Possibly. That is what we need to determine. The next day, Helen showed me a sealed legal envelope bearing Edward's signature across the flap. I recognized his handwriting instantly. Seeing it after 2 years affected me more deeply than any property document had. I reached toward the envelope, then stopped. Can I open it? Helen shook her head. Not yet. The trust instructions are unusually specific. She explained that before the memorandum could be opened, the ownership dispute had to reach formal legal review or another qualifying proceeding. Until then, the envelope remained sealed. Edward really planned for everything, I whispered. He tried. Helen placed another document beside it. And we have another development. Richard's partnership has filed a petition seeking clarification of access rights. So this is going to court? Most likely, yes. I looked at Edward's signature again. Suddenly the dispute no longer felt like a disagreement between neighbors. Whatever Edward had written inside that envelope had been waiting years for circumstances neither of us could fully predict. Does Richard know about this? I asked. About the memorandum? No. Does he know I control the trust? His attorneys will soon. I thought about Richard standing in my kitchen explaining how generous his offer was, about neighbors wondering why the quiet widow would interfere with progress, and about Edward carefully separating rights on land everyone else saw only as 18 empty acres. Helen, I said, before anyone goes into court, I want to understand every document Edward left. She nodded. Good. Then she opened a second file, thicker than the first. Because the easement is no longer the biggest issue. Helen opened the thicker file and turned it toward me. The first page was familiar. It was the Sullivan Land Preservation Trust, created 11 years earlier when Edward began thinking seriously about what would happen to the 18 acres after we were gone. I remembered signing documents, discussing taxes, and listening to Edward explain why keeping the land inside a trust would prevent future decisions from becoming unnecessarily complicated. What I had forgotten was how much authority he had placed in my hands. "Read this section," Helen said. I followed the paragraph slowly. As surviving trustee, I held authority to approve or reject a sale, negotiate easements, preserve all or part of the acreage, donate qualifying portions for community use, or authorize limited development if I determined it served the trust's long-term interests. "Edward gave me all of this?" I asked. "You both created the trust, Maggie." "But yes, after his death, the controlling authority passed to you." "Why did I remember it being more restrictive?" "Because Edward wanted the land protected from pressure, not frozen forever. He knew circumstances could change." Helen turned several pages. "There are safeguards. You cannot simply transfer everything to yourself or ignore fiduciary responsibilities. But within those responsibilities, the decision is substantially yours." I leaned back and looked toward the sealed envelope resting near her legal pad. Edward had always trusted me, but seeing that trust expressed in legal language felt different. And the memorandum? Separate from the controlling documents. It does not replace the trust. It expresses Edward's personal wishes about how he hoped you might use your discretion. But I cannot read it. "Not yet." Helen explained that the memorandum had been deposited with the estate records under instructions that it remain sealed unless there was a formal dispute involving access, sale, or disposition of the property. Richard's partnership had now filed a petition seeking judicial clarification of the corridor rights. Helen believed that satisfied the condition, but she wanted the court to confirm it before the envelope was opened. So Edward anticipated someone might eventually challenge access. He anticipated that valuable land attracts complicated questions. I smiled faintly. That sounds like him. Helen's expression softened. "There is something else you should understand. Richard's partnership has been negotiating as though the 18 acres are controlled by several older ownership interests. Some of the public records make the history look fragmented. The trust documents consolidate rights that are not obvious from a quick parcel search. Meaning they never traced everything far enough. That appears to be the problem." When I returned home, Richard was waiting near my driveway. He walked toward me before I had even closed the car door. "My attorney received a notice from Helen Brooks," he said. "Then you should discuss it with your attorney. She claims you have a controlling trust interest in the wooded property. Helen does not usually make claims without documents." Richard stared at me. "You own the 18 acres. The trust holds the property interests. I am the trustee. Why did you never say that?" I almost laughed. "When exactly should I have mentioned it? Before or after you explained that people like me should appreciate generous offers?" His face reddened with embarrassment. "That is not fair. It is exactly what you said. I thought you were only an adjacent homeowner. You never asked." Vanessa had stepped outside and was standing several feet behind him. "Richard," she said quietly, "maybe this is not the time." He ignored her. "The development group has already spent money on engineering and preliminary planning. I did not authorize that spending. We were negotiating with parties we believed had ownership interests. Then your attorneys should determine what those interests actually include." Richard looked toward the woods. "Are you planning to block the entire project?" "I have not decided what I am planning." "What would it take for the trust to sell?" "I do not know." "Everyone has a number, Maggie." I looked at him for a moment. "You keep saying that as though repeating it makes it true." Vanessa lowered her eyes. Richard took a breath and changed his tone. "The partnership can make a serious offer. Not an easement payment. A purchase offer for the acreage. Send it to Helen. Would you consider it?" "I will consider accurate information. That is all I can promise." 3 days later, an offer arrived. It was more money than Richard had ever mentioned before, enough that many people would have signed before finishing the first cup of coffee. I read every page. Then I placed it beside Edward's old photograph and felt no excitement at all. That surprised me. For 2 years after losing him, I had worried about making important decisions without the person who had shared every major decision with me for 42 years. Now someone was offering a large sum for land Edward had spent decades protecting, and all I wanted was to understand why he had protected it so carefully. The neighborhood rumors intensified. Carol told me several people believed I was holding out for more money. Another neighbor asked whether I realized how much new construction could increase home values. Richard did not speak to me for nearly a week. Vanessa did. She came over one evening carrying a loaf of pumpkin bread. "I owe you an apology," she said. "For what?" "I let Richard talk about you like you did not understand what was happening. I never corrected him because I assumed the same thing. I invited her inside. You barely knew me." "That is not an excuse." "No, but it explains part of it." She looked at Edward's photograph on the bookshelf. "Richard says your husband was a surveyor. And a civil engineer. And you worked with him. For more than 30 years. Vanessa shook her head slowly. "We lived beside you almost a year and knew none of that. You knew I grew tomatoes." She laughed despite herself. "We definitely knew that." The court notice arrived the following Monday. The hearing was scheduled for 3 weeks later. Helen called that afternoon. "The judge has agreed to review the trust documents and the condition governing Edward's memorandum." I looked toward the sealed copy. Helen had allowed me to photograph but not open. "So if the court confirms the condition, the memorandum can be read as part of the proceeding." My chest tightened. "In court?" "Yes." I had imagined hearing Edward's final thoughts alone in Helen's office, not surrounded by attorneys, neighbors, and the man who had spent months assuming I was standing in the way of his opportunity. "Do we know what Edward wrote?" I asked. "No. He prepared it privately and delivered it sealed." That night, I sat at the kitchen table long after dark with his photograph in front of me. Outside, the woods were almost invisible beyond the window. Somewhere inside Helen's files were words Edward had written for a future he knew he might never see. In 3 weeks, a court would determine whether those words could finally be opened. And for the first time since this began, I stopped wondering what Richard wanted from the land. I wondered what Edward had wanted me to do with it. The morning of the hearing, I stood in front of my bedroom mirror longer than necessary, trying to decide whether the navy cardigan I had worn to Edward's memorial service looked too somber. Then I caught myself and almost laughed. Richard had spent months judging what I knew by what I wore. I was not going to start dressing for his expectations now. I chose the cardigan, a cream blouse, dark slacks, and the small silver watch Edward gave me on our 30th anniversary. Helen picked me up shortly after 8. During the drive into Pittsburgh, she reviewed what would happen. "Today is primarily about clarifying the access rights and determining whether the trust conditions allow Edward's memorandum to be opened," she said. "Do I have to testify?" "Possibly, but I expect most of this to be documentary." "And Richard?" "His partnership will argue that the corridor should provide access based on their interpretation of the historical transfers. Their attorneys now know the trust exists." "Do they understand my authority?" Helen glanced at me. "They should." The courthouse was busier than I expected. Richard stood near the entrance with Vanessa and 2 attorneys. Aaron Mitchell, the project engineer, was there as well. Several neighbors had come, including Carol Jenkins. Apparently a disagreement that had once been described as one stubborn widow refusing an easement had become interesting enough to justify a morning downtown. Richard saw me and walked over. His confidence had returned, though it felt more deliberate than before. "Maggie, there is still time to settle this without making everything public," he said. "The records are already public." "You know what I mean." "I do." "The partnership's offer remains available. Then Helen can discuss it with your attorney." He lowered his voice. "If this goes badly, everyone loses time and money. Then we should hope the documents are clear." Inside the courtroom, Helen and I sat together while Richard joined his attorney several seats away. When the proceeding began, his legal team presented the development partnership's position professionally. There were no dramatic accusations. They argued that historical transfers supported roadway access through the corridor and that any conflicting interests should be interpreted in a way consistent with practical use of the larger parcel. Their attorney displayed maps showing the proposed road connecting the county route to the 18 acres. For months, Richard had spoken as though construction were merely waiting for paperwork. On those maps, the future neighborhood already seemed almost real. Then Helen stood. She began with Edward's original survey, the older deed descriptions, and the monument Aaron's crew had recently rediscovered near the drainage channel. Aaron confirmed that his team's preliminary stakes had been based on a different reference and that the line had since been corrected. Then Helen moved to the title history. One document after another showed that the narrow corridor had not transferred in the simple manner Richard's partnership originally assumed. Certain rights had been preserved separately and later incorporated into Edward's estate structure. I watched Richard's face change as the explanation became harder to dismiss. Helen finally introduced the trust. The Sullivan Land Preservation Trust holds the controlling interests relevant to both the 18-acre tract and the disputed access rights, she said. Richard leaned toward one of his attorneys. The attorney whispered something back. Helen continued. Following Edward Sullivan's death, authority to exercise the trust's discretionary powers passed to the surviving trustee, Margaret Sullivan. Hearing my full name spoken in that courtroom felt strangely impersonal. Helen placed the trust certification into the record. The judge reviewed it, then looked toward me. Mrs. Sullivan, you are the current trustee. Yes, Your Honor. And you have not authorized the proposed easement or sale. No, Your Honor. Across the room, Richard stared at me. It was not anger I saw. It was recognition arriving several months late. He finally understood that I had never been the neighbor standing beside someone else's development. The developers had been planning around land whose future I had legal authority to determine. Their attorney requested time to address the trust documents, but Helen explained that the development partnership had already received notice and copies through counsel. The discussion shifted toward the precise scope of my authority. The trust allowed me to negotiate access, approve a sale, preserve the property, authorize limited development, or pursue qualifying community uses, subject to my fiduciary obligations. The judge asked Helen whether the trust contained any mandatory direction requiring preservation. No, Helen said. The controlling instrument deliberately leaves substantial discretion to Mrs. Sullivan. Richard looked even more confused. Perhaps he had expected to discover some technical restriction that prevented his project. Instead, he was discovering something much simpler. The decision belonged largely to the woman he had spent months assuming did not understand real estate. During a brief recess, Vanessa approached me near the hallway windows. Maggie, she said quietly, I had no idea. I know. Did Richard? I looked toward him speaking urgently with his attorneys. Apparently not. She shook her head. He should have asked more questions. We all should sometimes. Richard approached before she could answer. So you could have told me from the beginning that you controlled the property. Yes. Why did you not? Because you came to me asking for an easement across my home property. I asked you to verify the records. You chose to keep explaining the value of your project instead. He looked down for a moment. I misunderstood the situation. You misunderstood me. That landed differently. He did not argue. When we returned to the courtroom, Helen raised the final issue. She explained that Edward had deposited a sealed memorandum with instructions that it remain unopened unless a formal dispute arose involving access, sale, or disposition of the property. The judge reviewed the relevant trust provision and supporting estate records. My hands were folded in my lap, but I could feel my fingers pressing tightly together. After several minutes, the judge looked toward Helen. Based on the petition presently before the court, it appears the specified condition has been satisfied. I stopped breathing for a moment. Helen stood. Then we request authorization to open and read Mr. Sullivan's memorandum. Richard turned toward me. The neighbors behind us became completely silent. The judge nodded. Helen opened her case and removed the sealed envelope I had seen in her office. Edward's signature still crossed the flap in the careful handwriting I knew better than my own. Helen carried it forward and placed it before the court. 2 years after I had lost my husband, and more than a decade after he had prepared those instructions, the seal was finally going to be broken. Until that moment, everyone in the room had been arguing about what Edward owned. Now we were about to learn what he wanted. Helen did not open the envelope herself. At the judge's direction, it was handed to the court clerk, who carefully examined Edward's signature and the date written beneath it before breaking the seal. I watched the envelope more closely than I had watched anything else that morning. For everyone around me, it was evidence. For me, it was the last unopened piece of a life I had shared for 42 years. The clerk removed 3 pages and passed them to the judge. The room remained silent while he read. His expression revealed nothing. Then he looked toward Helen. "Counsel, I believe this may be read into the record." Helen stood. "Thank you, Your Honor." She received the pages, glanced at me, and began. Edward had written the memorandum 11 years earlier, not as a command, but as guidance for whoever eventually controlled the trust. He explained that the 18 acres had never been acquired merely as an investment. Years before we bought our house, he had surveyed that land for an elderly farmer named Samuel Carter. Samuel had resisted several offers because the property contained an old spring, mature woods, and a meadow his family had maintained for generations. When Samuel eventually sold portions of his holdings, Edward helped structure the remaining tract so it would not be casually absorbed into surrounding development. Later, when an opportunity arose, Edward and his business partner acquired the remaining interests. I remembered Samuel, but I had never known the entire story. Helen continued reading Edward's words. He wrote that communities change and that change should not automatically be feared. He was not opposed to homes, roads, or responsible development. He had spent his career helping build them. But he believed this particular land deserved a higher standard of consideration because it served as one of the last undeveloped connections between our neighborhood and the creek valley beyond it. He asked the future trustee to consider drainage, trees, wildlife habitat, neighborhood character, and public benefit before considering price. Then Helen reached the part that made my eyes fill with tears. Edward had written directly to me. He said that if I was the person hearing those words, then circumstances had unfolded exactly as he suspected they might. He reminded me that for more than 30 years, every major decision in our business had been ours, not his alone. He wrote that I understood records better than most people understood their own homes, that I knew how to listen before deciding, and that I should never allow anyone to mistake quietness for uncertainty. I lowered my eyes. I could hear Edward saying it. Not because Helen was imitating his voice, but because every sentence carried the patient precision with which he had always spoken. Richard sat completely still. Vanessa reached for his hand. Helen continued. Edward did not tell me to reject development. He did not instruct me to preserve every tree forever. Instead, he asked that any future proposal answer one question: would the land still serve the community after the people making money from it were gone? When Helen finished, nobody spoke for several seconds. The judge thanked her and returned to the legal issue before the court. Edward's memorandum did not itself decide the access dispute, but it clarified the purpose behind the trust and confirmed that my discretion had been intentional. Richard's attorney requested a recess. Outside the courtroom, I stood near a tall window overlooking the street below. Helen came beside me. "Are you all right?" I wish he had told me. About the memorandum. About Samuel. About why the land mattered so much to him. Helen nodded. Maybe he thought there would be time. That was the hardest sentence I had heard all morning. Richard approached slowly. For once, there was no folder in his hand and no offer waiting behind his words. "Maggie, I owe you an apology." I turned toward him. "For what part?" He accepted the question without defensiveness. "For assuming you did not understand the project." For talking to the neighbors before I understood the title. For treating your questions like obstacles. You wanted the deal to work. That does not excuse it. Vanessa stood a few feet behind him. Richard looked through the window for a moment. I still believe development can benefit the area. So did Edward, when it was done responsibly. Would you consider a revised plan? I will consider one that starts with the land instead of the maximum number of houses. He nodded. That is fair. When court resumed, the judge did not award Richard's partnership the access rights it had requested. Instead, the existing title structure was recognized, and any future roadway agreement would require authorization through the trust. Richard's attorneys withdrew their request for broader interpretation and indicated that the partnership might return with a negotiated proposal. There was no dramatic victory, no angry confrontation, and no cheering courtroom. There was simply clarity. On the courthouse steps, Carol caught up with me. "Maggie, I am sorry," she said. "I believed you were holding out for more money. A lot of people did. You could have told us. Would you have believed me before today?" She thought about that and shook her head. "Probably not." I smiled. Then perhaps today was useful. That evening, I walked alone into the 18 acres for the first time since Edward died. Fallen leaves covered the old path. About half a mile from my house, I found the meadow Samuel Carter had once protected. The setting sun stretched across the grass, turning everything warm gold. I finally understood why Edward had refused to reduce this place to a number on a closing statement. Yet I also understood something else. His final wish was not asking me to preserve his past. It was asking me to make a thoughtful decision about the future. When I returned home, an email from Richard's development partnership was waiting. They wanted to meet again. This time, they were not sending me an easement agreement. They were asking what kind of plan I would be willing to consider. The meeting took place 10 days later in Helen's conference room, and this time Richard arrived without a purchase agreement. He brought Aaron Mitchell, another engineer, a land planner named Susan Caldwell, and 2 representatives from the development partnership. I had spent those 10 days walking the property, reading Edward's field notes, reviewing drainage maps, and making a list of what mattered to me. I was no longer thinking about whether development should happen. I was thinking about what kind of development the land could reasonably carry without losing everything Edward and Samuel Carter had protected. Helen opened the meeting by making one point clear. The trust was under no obligation to sell the 18 acres or provide roadway access. Any proposal would have to satisfy me as trustee and meet ordinary legal and environmental requirements. One of the partnership representatives, Daniel Reeves, nodded. "We understand. That is why we are here to listen." Richard remained quiet. I appreciated that more than I expected. Susan unfolded a preliminary map across the table. The original plan contained 32 homes, a broad internal road, stormwater infrastructure, and extensive grading near the meadow. "That plan is no longer realistic," she said. "Not with the corrected boundary and the trust's access position." "It was never realistic for the land," I replied. Susan looked at me carefully. "Tell us what you would change." I pointed to the western slope. "Start here. Edward's notes show seasonal water movement through this section. Your original road crosses it twice." Aaron leaned forward. "We confirmed that after the hearing. There is more drainage than the earlier mapping indicated." I moved my finger toward the meadow. "And this should remain open." Daniel asked why. "Because it feeds water toward the creek valley, because mature trees protect the slope below it, and because once you grade that section, you cannot put it back the way it was." Nobody interrupted me. That alone made the meeting feel different from every conversation Richard and I had shared before court. I suggested reducing the number of homes, keeping the meadow and wooded slope under permanent protection, and creating a walking trail that could connect our neighborhood to the preserved section. I also wanted a wider buffer between existing homes and new construction. Daniel studied the map. That would remove a substantial number of building sites. Yes. It changes the economics. Then determine whether the economics still work. Richard finally spoke. What number of homes would you consider? I am not deciding by number alone. Show me what the land supports. Susan smiled slightly. That is actually how planning is supposed to begin. Richard accepted the comment without reacting. Over the next 2 hours, the conversation became surprisingly practical. Aaron discussed drainage. Susan moved road alignments. Helen raised questions about maintenance and liability. Daniel calculated what reduced density might mean financially. I listened, asked questions, and occasionally pulled one of Edward's old field sheets from my folder. At one point, Aaron laughed quietly. These notes are better than some digital records I receive today. Edward believed measurements were useless if nobody could understand them 20 years later. He was right. By the end of the meeting, the 32-home concept had been reduced to a possible 14-home plan concentrated on the higher, less sensitive portion of the acreage. Nearly 9 acres would remain protected. The meadow, spring area, and wooded slope would be excluded from construction. The roadway would follow a different alignment, avoiding my residential property entirely. Nothing had been approved, but for the first time I could imagine a future that did not require choosing between selling everything and preserving everything exactly as Edward had left it. After the others departed, Richard stayed behind. "Can I ask you something?" he said. "Of course. Why did you not simply reject us after court?" I considered the question. "Because Edward did not ask me to." "You could have." "Yes. After the way I treated you, I probably would have." I smiled. "That may be one reason Edward made me trustee instead of you." Richard laughed, then looked embarrassed. "Fair enough." His expression became serious again. "I spent months thinking you were afraid of change. I was afraid of making the wrong decision without Edward." It was the first time I had admitted that aloud. Helen, still gathering papers at the other end of the table, said nothing. Richard nodded slowly. "I am sorry." "You already apologized." "I know. This one is for assuming your hesitation meant you did not understand what was happening. That is a different apology." "Yes." When I returned home, Vanessa was trimming dead flowers near their porch. She crossed the lawn when she saw me. "How did it go?" "Better than I expected. Richard texted me that the plan might shrink considerably." "It should." She looked toward the woods. "Would you really allow some houses?" "Possibly. I thought Edward wanted the land preserved. He wanted it respected. That is not necessarily the same thing as never allowing it to change." That evening, I walked to the meadow again. The leaves had thinned enough that I could see farther across the valley. I imagined 14 homes tucked near the upper ridge instead of 32 spreading across the entire tract. I imagined neighbors walking along a trail through woods that would remain protected long after I was gone. For the first time, the idea did not feel like surrender. It felt like stewardship. 2 weeks later, Susan sent the revised concept. 13 homes, not 14. More than 9 acres preserved permanently. No road through my yard. A conservation agreement protecting the spring and wooded slope. A public walking trail maintained by the Homeowners Association. Helen reviewed the documents and found them promising, although far from final. Then she reached the financial proposal. The partnership had increased its offer despite reducing the number of homes. "Why?" I asked. "Because," Helen said, "they finally understand what they are buying." I looked at the figure. It was enough to change my life, though at 68 I was not particularly interested in changing my life dramatically. "There is something else," Helen said. She turned to the last page. The partnership was willing to name the preserved meadow and trail after Edward and Samuel Carter. I read the proposed name twice. Sullivan Carter Preserve. My eyes filled before I could stop them. Edward had asked one question in his memorandum: would the land still serve the community after the people making money from it were gone? For the first time since the orange stakes appeared behind my house, I believed I might finally have an answer. The revised proposal stayed on my kitchen table for 4 days before I signed anything. The number on the financial page was substantial, but Edward had spent his entire career teaching me that the most important part of a land agreement was often the page nobody hurried to read. Helen and I reviewed the conservation restrictions, road maintenance obligations, drainage responsibilities, construction limits, and permanent protection language until every promise discussed in that conference room existed in writing. More than 9 acres would remain protected from residential construction. The spring, meadow, creek slope, and oldest section of woods would become part of the Sullivan-Carter Preserve. The walking trail would remain available to the surrounding community during daylight hours, and the Homeowners Association would fund its maintenance without transferring that burden to existing residents. The development area would contain 13 homes, all located on the higher ground. No construction traffic would cross my backyard. No roadway easement would divide my property. Most importantly, the preservation restrictions would survive future ownership changes. If the partnership sells the project 5 years from now, these protections remain. I asked Helen. Yes. If I sell my house? Yes. If the Homeowners Association changes leadership? Yes. I looked at her. Then I am ready. The closing took place in early December. Richard attended with Daniel Reeves and the partnership's attorney. He was different from the man who had once sat in my kitchen explaining how fortunate I should feel to receive an easement offer. He asked questions, listened to the answers, and did not try to hurry me. When the final document reached me, I paused before signing. For a moment, I thought about Edward sitting beside me at hundreds of closings over the years. He always checked the legal description one last time, even when everyone else was already putting away their pens. So I checked it again. Richard noticed. Edward would have done that, would he not? He asked. Every time. Then we can wait. I finished reading and signed my name. Nothing dramatic happened. There was no applause, no sudden feeling that I had won something. I simply felt peaceful. The land had a future, and for the first time since Edward died, I knew I had made a major decision without him while still honoring everything he had taught me. Construction did not begin until the following spring. Before any equipment arrived, survey crews marked the protected acreage with permanent monuments. Aaron invited me to walk the boundaries with him. We started near the old drainage channel where his crew had found Edward's monument months earlier. This little piece of metal caused quite a problem, Aaron said. No, I replied. It solved one. He smiled. By summer, the new road began taking shape along the higher ridge, far from my backyard. Trees that had originally been marked for removal remained standing along the preserved slope. The meadow stayed untouched. Susan's final plan placed the homes carefully enough that from the walking trail, there were places where you could barely see construction at all. Some neighbors who had once complained about delays began using the trail before the first house was completed. Carol walked there almost every morning. One afternoon, she stopped by with photographs of wildflowers growing near the meadow. I suppose I owe you another apology, she said. You already apologized. I know, but I was so certain more houses meant more value. Sometimes value is what you leave alone. She smiled. Edward said things like that, did he not? All the time. Richard and Vanessa eventually became friends rather than simply neighbors. Richard never stopped being ambitious, but he became more careful about assuming that quiet people had nothing to contribute. One evening while we were sitting on my porch, he admitted something that made me laugh. When I first brought you that easement offer, I thought you were going to ask your husband what to do. I looked at him. My husband had been gone for 2 years. I know. Vanessa reminded me afterward. That made what I said even worse. You were very confident. I was very uninformed. Those two things travel together surprisingly often. He laughed and raised his coffee cup in surrender. The Sullivan-Carter Preserve officially opened the following October, almost 1 year after I first noticed the orange stakes. A small gathering was held near the beginning of the trail. There were no grand speeches. Helen came, along with Aaron, Susan, Daniel, several neighbors, and members of Samuel Carter's extended family who still lived in Pennsylvania. Samuel's granddaughter, now in her 70s, stood beside me when the simple wooden sign was unveiled. She touched her grandfather's name and quietly said, "He would have loved this." I looked at Edward's name beside it. So would my husband. Later, after everyone left, I walked alone to the meadow. The 13 new homes were visible through the trees on the upper ridge, but they did not dominate the landscape. Families would live there. People would build ordinary lives, plant gardens, complain about property taxes, wave to neighbors, and eventually forget how complicated the land had once seemed. Below them, the meadow would remain open. The spring would continue running toward the creek. The old trees would still shade the trail. I sat on a bench near the edge of the field and thought about Edward's memorandum. He had not left me an answer. He had left me responsibility. There was a difference. An answer would have allowed me to follow instructions. Responsibility required me to understand the land, listen to other people, weigh competing interests, and decide what could still matter decades after I was gone. I finally understood why he had trusted me with that choice. For years, neighbors had known me as the quiet woman who watered tomatoes, collected her mail, and kept mostly to herself. Richard had looked across a property line and seen someone he believed could be persuaded with a large enough check. None of them knew about the decades I spent beside Edward studying surveys, deeds, roads, drainage systems, and property records. But I learned something too. I did not need everyone to know my history before respecting my own judgment. Quiet was never the same as powerless. As the evening light settled across the meadow, I touched Edward's old silver watch on my wrist and started home. Behind me stood land that had changed without being erased, a neighborhood that had grown without consuming everything around it, and a decision that belonged neither entirely to Edward's past nor to Richard's plans for the future. It belonged to the balance between them. And that, I realized, had been Edward's final wish all along.